Yo, what up guys? It's Derp here with another video about the Ironmace vs. Nexon court case. Today I'm going over everything that's happened in the last week. It's a lot of new information. I've had some time to consult some people and talk to a bunch of people and kind of go over and collect my thoughts, so here's what we got. What I'm going to go over is Nexon's opposition document for the motion to dismiss, Ironmace's request for a stay or a temporary hold on the discovery process, a phone call I had with the court administrator for Judge Lin. I'm going to go over Ironmace's response to Nexon's opposition to the dismissal, and I'm going to go over where we're at now and kind of how things are playing out. And that's also going to include my TLDR. So at the end of the video, there's for sure going to be a TLDR, but I'm going to try to keep this one shorter. It's only a few pages long, so it should be quick. As always, super huge thank you to everybody who's been watching, subscribing, leaving comments, everybody who's been leaving super comments and super thanks and everything, and joining us on live stream, everybody who's been joining the guild. And big thank you to everybody whose name is up on the screen over here. Because of you, I mean, I think you guys can notice, I have a new mic, I have a new light, I have a mic stand, a new set of in-ear monitors, and a new camera stand on the way. I've also upgraded my camera, so it should be recording in a little bit better quality. And that's all happening because of you guys. I couldn't do this without you. Literally, I couldn't. So thank you. But let's get right into it. Nexon's opposition document for the motion to dismiss. To keep this short, I'm not going to read the 35-page document. I'm just going to summarize it. For the most part, Nexon's argument against Ironmace's dismissal is that the Korean courts do not have an adequate discovery process, nor can they access the information they need to, like source code. Therefore, they feel that Korea is an inadequate venue for the case. They also go over how getting witnesses from U.S. to Korea would be difficult or impossible because Korea does not subpoena foreign witnesses the same way that the United States does. Another argument they bring up is that the employment contract was not signed by Ironmace as an entity, nor would the clause in said employment contract remain intact after Mr. Park and Mr. Choi have left Nexon. To prove these points, they cite several cases. However, they do a pretty, in my opinion, poor job of internally quoting a large majority of them. They just reference the cases, then kind of move on. A lot of that document is questionable at best, in my opinion, and in the opinion of like actual lawyers and stuff. I'm not an actual lawyer. This is not legal advice, all that good stuff. But people I have talked to that are actual lawyers, they're not acting in the capacity of lawyers to me, so don't take this as legal advice either. But they basically said that that document was 35 pages because they want it to be confusing intentionally, and they're leaving a lot of information out intentionally. It's not perjury or lying directly, it's just leaving out facts and statements, right? So it's kind of misleading. But there are some damaging points in there against Ironmace, but I'm not even going to include them in this video because they all get immediately destroyed, in my opinion, by Ironmace's rebuttal. At first, I was kind of hesitant, and it made me worry a little bit about Ironmace's case, but after speaking with some lawyers, and especially after reading what we read last night on live stream, and then talking to my friend who's a lawyer about it, like, it's not as bad as it sounds. They make a lot of big claims without a lot of evidence to back it up, is essentially what it is. They make some valid arguments, but they're all opinion-based, and the evidence that they do cite isn't really valid, or not pertinent to the situation. So let's move on to the next document that showed up, which was Ironmace's request for a stay or a temporary hold on the discovery process. Shortly after Nexon sent their opposition to Ironmace's dismissal, Ironmace then retaliated with a motion to stay discovery, which is basically just putting discovery on hold until after they figure out the dismissal, if the dismissal has been granted or not. This is extremely important for them because it would save Ironmace a ton of money fighting a case that might be dismissed anyway. Their argument was that going through the discovery could end up costing them, Ironmace, the court, and Nexon hundreds of man hours and tens to hundreds of thousands of dollars. It's extremely, extremely expensive to do discovery in court cases in the United States, especially when you're operating internationally and everything has to be translated or shipped, you know? So Ironmace estimated that the discovery alone could cost them somewhere over 250,000 United States dollars, which would cause significant harm to their business and their chances of fighting the case long term. Not only would it be a waste of time and money for Ironmace and Nexon, it would waste the time and money of the United States court system on a case that has a chance of being thrown out. So what they're asking for is for the court to just put discovery on hold until whether they know if the case is actually going to move forward or not. In this document, there was also an important date, which was July 14th, which was the first day that the dismissal argument could be heard. And they could have held the dismissal hearing then. But I called the court administrator around 3 p.m. on July 14th. And it's Honorable Judge Lin's court administrator to try to get some answers to a few questions and to see if they were going to hear oral arguments or have some kind of hearing that day. And what I wanted to know was fairly simple. I wanted to confirm the dates of the case. I wanted to ask the judge, or if the judge was going to hear any oral arguments that day. I wanted to ask if she can give me any indication of which way the judge was leaning on the dismissal or the stay of discovery. What she told me was pretty interesting. Most importantly, she confirmed the dates for the early case conference. So that is officially July 26th, according to the judge, or according to the court calendar and the court administrator. So that's where we should learn more about injunctions and most likely the dismissal. She could also confirm that there would be no oral arguments on the 14th, so they didn't have any oral arguments that day, nor were any scheduled as of yet until July 26th. So as far as I know, this is straight from the court administrator's mouth, there isn't any oral arguments scheduled at all until July 26th. The closest thing there is would be on the 21st. There is a ruling for the stay of. There's supposed to be notation for the stay for the hold on the discovery. So that's really it. But for the dismissal, there's nothing on the books until at least July 26th. That can change, but for now, that's the date. When I asked if that meant that the judge has enough information to make a decision on the motion for dismissal or put a stay on discovery, the court administrator kind of skirted the question, basically stating like she can't really give me that information because I'm not directly involved in the case, even though I have access to court filings and stuff. I don't have access to their case specifically. And Washington's rules and their laws on the situation is that they only give access to what they're federally required to give access to, and then everything else is up to the discretion of the defendant or the plaintiff, and sometimes the court. But unless I get express permission from either Ironmace or Nexon or the court to get access to more files, then I can't look into that stuff. Like some of the oral arguments or the transcripts from oral arguments, they won't give me access to it. However, when I asked about the timeline for the court, the administrator gave me access to the court calendar for the publicly available, the stuff that I do have access to. So like the PACER information, which I already had access to, but they expanded my accessibility to the court calendar in that regard. So I now have access on my PACER to a little bit more information than what was already there. It's not really anything significant, but I could see a few new dates and if and when arguments are added, I could see that kind of stuff. She also said that just because there were no oral arguments on the schedule, that didn't mean arguments could not be submitted. And they have been requested by Ironmace and Nexon have both requested oral arguments. And that would be important coming up later, because later in the day on the 14th, Ironmace submitted a response to Nexon's opposition to their motion for dismissal. And what this means is that either the judge or Ironmace's lawyers felt the need to expand upon portions of Nexon's disagreement. Rather than hearing oral arguments, the judge most likely asked Ironmace to refute Nexon's claims in a document and expand upon some of the arguments that Nexon made. In this response, Ironmace makes it very, very clear that they don't mess around. They are not messing around this time, like, at all. Very clear language, very direct. Any opinion was also backed up by facts and evidence and direct citations and internal quotations from previous precedent and other U.S. cases and Korean cases. And it was like all fact-based and all evidence-based, at least from what I could see. And everything that was opinion was also backed up by fact. So they didn't leave anything out. And I'm just going to kind of read some of the clippings from the documents that best summarize their argument. So Nexon cites two out-of-circuit cases in their argument, and it's of opposition, and states, courts have repeatedly held where a plaintiff sues in a jurisdiction designated in a permissive forum selection clause, a defendant seeking to transfer a case outside of the permitted forum must meet the heightened Atlantic Marine Standard. However, that is not an accurate statement in the law of the law in this circuit. So the law that Nexon was citing isn't even an accurate statement for the law in the circuit they're currently arguing in. So it doesn't relate to Washington or the District of Washington's rulings. It's not a standard they operate by. So Nexon is basically citing cases that don't even pertain to the District of Washington or the Western District of Washington. In the simplest terms, basically, Nexon is citing multiple cases that have nothing to do with relevant law where they're actually fighting the case. And then it goes on to say, indeed, Nexon cites these contracts as evidence of an element of its trade secrets claim, namely that it took reasonable measures to protect its trade secrets. It is not. See rebuttal. It is not. See rebuttal declaration of Professor Gyho Lee. And the reason why it's not evidence of the trade secrets is because Nexon is also arguing, and I go over this a little bit later, Nexon is also arguing that the contracts are now invalidated anyway. They're null and void. So it doesn't really make sense for them to try to argue that the contracts are still in existence and invalidated at the same exact time. Nexon's argument is the height of bad faith because Nexon has not even made a request for document submission order in the Korean litigation as to Ironmace's source code. And what this is saying is that essentially Nexon has had access to all of Ironmace's information for, according to Ironmace and the Ironmace's lawyers, for almost 2 years now. Ironmace and Mr. Choi have both been raided several times and have given over as much information as that the court, that police, that Nexon has asked for them or from them. They've given it all over. They were raided. The police went and took all of their files, including source code and other information. And not a single time since they've pressed criminal charges against Mr. Choi has Nexon actually asked for source code. In fact, they have actually argued that the source code isn't relevant to the case in Korea. However, their entire argument that the case should move forward in the United States is based on the fact that they can't get access to the source code in Korea, but they've never even asked for it. So the argument does not pass superficial scrutiny. If Nexon believed that Korea cannot provide any remedy for a claim of copyright infringement, why did it sue Ironmace there? Defendants are unaware of any decision ever finding Korea an inadequate forum by virtue of discovery procedures. So that means that nobody has ever found Korea an invalid venue for this type of legal proceeding based on the discovery on an inadequate discovery process. They're also arguing that if Nexon does think that Korea is an inadequate venue to hold this trial, why are they suing Ironmace there? So why would they bring a lawsuit against Ironmace in Korea if they don't feel that it's an appropriate venue? Which I thought was hilarious. I think that is a hilarious statement, but it is very, and that, I mean, it's an opinion, but it's a very valid question that brings into question a lot of the claims from Nexon's document. But the part that's interesting is that the defendants are unaware of any decision ever finding Korea an inadequate forum by virtue of discovery procedures, because that's the basis of Nexon's entire opposition for discovery. So, moving on. While these points are enough to refute nearly every claim Nexon had in their objection to Ironmace's dismissal, Ironmace also felt the need to explain that the DMCA itself is the reason why Ironmace had to geoblock Korea from Playtest 5. So, according to Nexon, Ironmace is one of the reasons why they should have try the case in the United States and not dismiss the case in the US is because Ironmace geoblocked Korea in Playtest 5. However, what Nexon didn't say is that Ironmace received some form of rating or tag from Steam, and that's how games get a lot of their rating, like their, I think it's like ESRB and PEGI and all that stuff. They get these special tags from Steam that say what rating they get, right? It's some kind of international rating system. I'm not sure of exactly how it works. But because they were no listed on Steam, that means they no longer had this rating or tag to submit to Korean authorities. Therefore, they were not legally allowed to distribute their game in Korea. So, because of the DMCA, they weren't allowed to distribute the game in Korea. So, Nexon prevented them from distributing in Korea because of the DMCA and because they were no longer allowed on Steam. To make matters worse for Nexon, Ironmace also argues a point that I have kind of been hammering home for a while now. Nexon cannot argue that the employment contract is both valid and invalid at the same time. They also cannot argue that Ironmace is both a separate entity from Mr. Park, and Mr. Choi, while also arguing that they're intrinsically linked, which they have made. Nexon has tried to make that claim in almost every single one of their documents now that they've put forward. Either Ironmace is bound to the same contract and legal stipulations as Mr. Park and Mr. Choi as the owners of Ironmace, or it is not. They have to make one argument or the other. And that's exactly what Ironmace says in these documents in both Korea and the United States. It's something I've kind of been like, hey, why isn't anybody talking about this? And it's something I've been hammering for since the beginning of the case, since the first time I saw the complaint. But this is just from the main document. There are two documents that are super important to the case, and two that are kind of cursory. One's from a Korean and English expert and certified court interpreter, but I'm not going to really go over that here. But there's more in the declaration from Ironmace's Korean lawyer, Young Jun Jeon. I probably murdered that. I'm sorry. I do not, Korean. I don't speak Korean, and I have no idea how to speak Korean. So I apologize for my terrible pronunciation. But to paraphrase that document, Nexon has already had access to most of, if not all of Nexon's games files, or the ability to request said files for over a year now, since the investigation of Mr. Choi began. How? The Korean police and investigators already have access to all of this information via the raids against Mr. Choi and Ironmace. And Nexon has the legal right to access evidence regarding this investigation because they are part of the people who ordered it. They are the plaintiff in that criminal case. So they have access to the discovery process in that criminal case. However, they have never asked for the Korean courts, any third-party investigators, or the police for any access to the source code, according to Ironmace's Korean lawyers. Furthermore, Nexon have refused to hand over any source code related to P3. This includes to third parties, to Ironmace's lawyers, or to the courts. However, Nexon and Ironmace both have until the 19th of July to deliver evidence to third-party investigators in Korea. But again, Nexon has refused up until this point to give anybody any access to P3 source code, even though they are claiming that the entire reason why the case shouldn't be dismissed in the United States is because they don't have access to Ironmace's source code. So to me, what it really sounds like is Nexon is directly asking for all of Ironmace's source code and all of Ironmace's information, not the courts, not the third-party investigators. They want it to be given directly to them from Ironmace, but they haven't even asked anybody for it. So their argument doesn't hold any water as far as I'm concerned. Now, where are we now? What happens next? That is pretty simple. Ironmace is gaining some ground via solid arguments, but nothing has really been determined by a judge. Nothing really changes with these. The stay for this, the motion for a stay on discovery is pretty huge for Ironmace if that passes, but we won't know about that until July 21st, and we won't know about the dismissal or any kind of injunctions or early access probably until at least July 26th. However, in my opinion, Nexon has grossly misrepresented the facts and evidence in almost all of their documents that they've put forward to date. Not to the point where I think that they've committed any form of perjury, but they are towing a line of misinformation that might end up hurting them in court. They are very obviously obfuscating the truth and muddying the waters so that this case takes a lot longer than it should. It's very noticeable by the simple fact that Ironmace's rebuttal to their argument was only 7 pages, and Nexon's filing was 35 pages. Most of it was repeated quotes and repeated citations without any actual internal quotations. And then they submitted 150 pages of documentation that don't really have anything to do with the court, including they cited a fan Twitter, and they cited Nexon cited information that So Bad Strange had provided a PDF that So Bad Strange made, and they claimed that it was from Ironmace or a representative of Ironmace, and it wasn't. It was from a YouTuber. So a lot of their stuff that they're citing is just literally random stuff that they're finding on the internet, and then they're claiming that it came from validated sources, but it doesn't. So that kind of stuff will end up hurting them in court. To me, it looks like they aren't really trying to necessarily even win this case or even win the motions by presenting facts. To me, it seems like they're just muddying the waters enough to make forming any kind of conclusive decision extremely difficult and time-consuming. They're just trying to stall. However, Ironmace's attorneys have done an amazing job, at least in my opinion, of clearing the air and setting the record straight using clear language, facts, legal precedent, state and federal laws, and rulings from both Korea and the United States. Ironmace's attorneys are amazing. They're, in my opinion, destroying Nexon's attorneys just with facts, just straight up facts. If you're not lying, you don't need to do what Nexon is doing. If the facts support your case, you present the facts. If the facts don't support your case, you make shit up. That's pretty much it, right? So Ironmace has also consulted, language experts and legal experts that are very well versed and court certified to back up their claims, as seen in 2 other documents. I'm not really going to go over those, but they're pretty interesting reads, and I'll link them in the description. But all of these people are making these claims under penalty of perjury. One of them is a 19-year veteran he managed the U.S. Korean Affairs program for UCLA or something. I can't remember the exact language, but he managed that for 19 years, lived in Korea. He's also a professor and a court certified translator. Then that guy just completely destroyed a lot of Nexon's arguments about language issues. And that's linked in the description below. I also have all these files up on my Patreon. But as far as early access in the case moving forward, we basically just have to wait. We'll know more about the motion to delay discovery on or before the 21st of July. We'll know more about the dismissal and injunction on or before the 26th of July. This has nothing to do with what's going on in Korea. That's a completely different timeline. So the TLDR is that it's highly likely that Ironmace's request to have discovery delayed is going to be granted. That is pretty common in these kind of cases, according to my friend who's a lawyer. This is fairly, in corporate law, this is fairly common, at least in my opinion and my friend's opinion. So I also believe that Ironmace's chances at a dismissal have significantly risen, as their lawyer makes a very valid fact-based argument as opposed to Nexon's opinion and speculation-based argument. And as we've seen in these documents, all of Nexon's arguments are kind of proven to be half-truths at best. Either way, we'll know more before the 26th. Here's some important dates to remember. July 19th is the final day for a Korean third-party investigation of evidence. If they don't make a ruling on that day, I believe they have to make a ruling within the next 30 days after the 19th, so by August 19th. July 21st is the final day to decide the stay of discovery in the United States. And then July 26th is the final day for early case conference, meaning all the pretrial hearings should be wrapped up by then. And that includes injunctions and most likely the dismissal hearings. In closing, as always, you guys are champions. I love you. Thank you for watching. Thank you for your support. Because of all of you guys, we just broke 1,000 subs. This community is growing faster than I ever thought it would, and faster than I can manage alone. So I'm going to be looking for moderation, help, and Mrs. Derp and I are doing our best to keep up with everything. But with the rapid growth of this channel, we're doing our best. We're going to keep growing. I got the new light, I got the new microphone, I got the improved camera setup. Mrs. Derp is decorating the wall behind me. We're trying to improve the setup as much as possible. So I can't, and that's all because of you guys, and I can't thank you guys enough. We couldn't do this without you guys, your help, and without the help of the community. If you haven't already, please don't forget to like, subscribe, and hit that bell icon. And if you want more content faster, be sure to join the guild, either through the Patreon or the YouTube membership. Those links are below. You guys have a wonderful rest of your evening, and thank you guys all so much. Peace.